Hello, everyone, and welcome. My name is Stuart Teicher, and welcome to the Ethics is Cool podcast. It makes me laugh every time I even say the name of the podcast, because the idea that anyone could find ethics cool, well, actually, it's not a surprise to me. I find it cool. I think you'll find soon that our guest today, Mark, finds it cool. But I named it almost tongue-in-cheek. I think I named it to will the idea into existence. This program today is brought to you by me and my book. I just wrote a book called How to Stop Hating the Law, a guide. What did I call it? I can't remember the subtitle of my own book. How to Stop Hating the Law, a Path to Hope for Miserable Attorneys. So if you're interested in that sort of thing, you can go to my website, that's my email, stuartteicher.com, and you could go to the section that says buy my book and you can get a copy if you want. Today we are joined by a very special guest. Mark, why don't you introduce yourself?
Good morning, Stuart. My name is Mark Gifford. I have been bar counsel for the Wyoming State Bar for the last 14 years.
And I thank you so much for joining us, Mark. Joining us, like there's a whole crew here. It's me, joining me, and all the people who are listening. I'm trying to go across the country and to interview as many bar counsel, disciplinary counsel as I possibly can. And I'm so happy that you agreed to join us. And we actually met in person not too long ago, right? Just 2 weeks ago?
We did, in Chicago.
Yeah, we were at the National Association of Bar Executives meeting, and it was nice for us to meet in person. So I thought maybe we would start. I just ask you, how did you find your way into the disciplinary system, into the world of attorney ethics?
Well, I actually didn't start this job until I had been in private practice for 30 years as a trial lawyer, and as in the last half of that private practice period, a really busy mediator. And in 2010, a friend of mine who served as part-time bar counsel for the Wyoming State Bar reached out to me and said, "Hey, I'm gonna give this job up, but you ought to apply. It's a really good gig, and it's only 8 or 10 hours a week, and it pays pretty well." And I thought that would blend pretty well with my mediation practice, so I signed up, and I found within about 10 minutes of my first day that it really wasn't a part-time job, and it wasn't anything that I could do a good job on for 8 or 10 hours a week. So I actually quit twice, but my quitting didn't ever take. And finally I just gave up and took the job full time and moved to Cheyenne for my practice in Casper, and the rest is history.
Every time you tried to get out, they pulled you back in.
Yeah, it was just karma didn't want me to leave, I guess.
So if you had to think back, so how long has it been that you've been there?
Just about 14 years. It'll be 14 years at the end of this year. Yeah.
So I guess it's stuck, huh?
It did.
What do you think? What was it that kept you there?
Oh, I work with great people, and we've really built something that we're proud of here at the Office of Bar Counsel. And I'll talk more about that as we get further into it. But it's rewarding work. The discipline side is grimy and not fun, and honestly I don't think you want anybody in a disciplinary counsel role that thinks it is fun.
Right.
I think that's the wrong approach, but we do everything we can to help lawyers, because if we're helping lawyers stay out of trouble, their clients are being better served, and it's a win-win for everybody.
So do you have two different sort of angles that you deal with in your office? Because you mentioned the part of the disciplinary thing. So where I'm in New Jersey, I sit on the disciplinary committee, and we deal only with disciplinary stuff. But I'm guessing from what you just said, you deal with both sort of guidance and discipline?
Yeah, the story there is that when I started this job, there had long been an ethics professor at the University of Wyoming College of Law, which is the only law school in Wyoming. And his name was John Berman, and he was revered. And he was kind of the ethics hotline for the whole state. When private practice lawyers or government lawyers ran into a bind and weren't sure where if they were on the right path with their interpretation of the rules, everybody would call Professor Berman. And when I started this job in 2011, he was really battling some health issues, neuromuscular disease that eventually took his life. And so I didn't want to see that service lapse, because I had used Professor Berman, and I thought maybe this office was a good place to fire up an ethics hotline. Initially, I'll all my colleagues in other jurisdictions thought that was nuts. Who's gonna call the police to find out if they've broken the law? But we did it, and it has really caught on. It's probably our most popular member benefit for members of the Wyoming State Bar. We're a mandatory bar here, and so now I have a part-time deputy, and she and I take between 8 and 10 ethics hotline calls a day
A
or
day.
email, and we do that in real time.
Mm.
We're very proud of that, and our members just love it. So, and then as bar counsel for Wyoming, Wyoming is the smallest jurisdiction in terms of membership, number of lawyers that are licensed here. So I wear a lot of hats at the bar office. There are only 8 employees here. That includes our admissions director, our bookkeeper, our executive director. And so in my role as bar counsel, I serve both as disciplinary counsel, um, run the ethics hotline. I also kind of have a hand in fee arbitration, unauthorized protection of law. I serve as general counsel of the Wyoming State Bar. So it's an interesting job because it pulls in every aspect of the legal profession. We are charged by statute with regulating the legal profession in Wyoming on behalf of the Wyoming Supreme Court. So
That's interesting. Let me ask you a question about that hotline. You said you take the calls in real time. Do you give them answers in real time? Is there a delay in the response?
Typically not. When I first started, I wasn't that as comfortable with the rules as I've become. So there were times when I'd say, "Ooh, that's a good question. Let me do some thinking on it and some reading and get back to you." Now we've taken so many calls. By any measure, we've had more than 10,000 calls in the last dozen years, and so it makes Melinda, she's the deputy bar counsel, Melinda and I both better at our discipline jobs because we know the rules so well, and so it really is kind of it feeds everything. We're helping our members, which makes us. It's the only reason some days we don't hang ourselves in the shower because the discipline work is not fun and often just arduous. And so when we feel like we're helping lawyers, they're also serving their clients better, and that's a one fewer disciplinary case that we have to have. So we really believe in the service.
Yeah, I hear you, and it makes sense too because I don't know if I mentioned I teach at Georgetown Law. I've taught professional responsibility there as an adjunct now for close to 10 years, and it's the same way. When they ask you the questions, that's when you get to know the rules even better. I remember in the beginning I thought I knew the rules, and then some of the questions that the students were asking me really threw me for a loop. And at this point now, very little surprises me, but that's like been a long time of answering those questions. Speaking of students, do you ever get any law students calling the hotline? About either stuff in their practice or maybe character and fitness stuff?
Yeah, that's another role that I have. I assist our admissions director in reviewing character and fitness reports and determining whether there's a case that we need to refer for hearing. We have a character and fitness committee that serves as the hearing tribunal. So the calls I get from University of Wyoming College of Law students are typically either admissions related. Do I need to disclose this? How do I deal with this? Or often the University of Wyoming College of Law has a really robust clinical program. We have several legal clinics. And so those students are actually practicing law under the supervision of a faculty instructor. So they'll get into an ethics bind and their instructor says, call Mark Gifford. And so it's not unusual for us to have queries like that from law students.
I have a question for you about that. I didn't plan on asking you about this, but it's something that my students ask me a lot. How do you deal with, if a student has a job in the summer and they think that they're not a lawyer yet, right? They're just a summer associate, and they think that they know one of the clients of the firm. Is that technically a conflict, or is that something that they basically need to bring to their boss's attention and then let the boss deal with it as if they're a non-lawyer? That sort of thing. What's your feeling on that?
I think summer interns or law clerks fall under the heading of non-lawyer assistants. So the supervising lawyer has all the duties of supervision that go with that. And so it's not unusual this is a slightly different context, but it's not unusual for a paralegal to leave one firm, go to work for another firm, and has cases going against clients of the paralegal's former firm. And so we talk through situations like that and determine whether it's something you can handle with a Chinese wall, if disclosures need to be made, all those things. So I think summer interns or law
Yeah.
clerks fall kind of
It,
the same.
I find that interesting because, like, take for paralegal, for example, right? Like you just said, if you bring them over from another firm, they could have confidential information. And yeah, putting up some sort of screen or something. But I find it interesting that, I mean, I guess the rules don't really address that. They talk about screening lawyers, but it doesn't talk about screening, non-lawyer assistants, right?
I think the way you kind of back into that is the duty of supervision and the duty to
Mm.
make sure your non-lawyer assistants are complying with the rules of professional conduct. So our guidance that we offer in situations like that is you can't go wrong over disclosing, and you can't be too cautious with those situations, because we'll get complaints where um, a client has the law firm and the paralegal that worked on the client's case went over to the opposing firm, and then we hear from the adverse party that that's not fair. There's a
Right.
conflict here, and we've been able to talk through most of those. I don't think any of those has resulted in discipline, but it does serve as a reminder that the responsibilities we as lawyers have for our non-lawyer assistants are serious, and
Yeah.
we need to take them seriously.
Yeah. So let's go over to the disciplinary side. What do you think? You know what? It's not necessarily just the disciplinary side. It could be on the other side, the hotline side too. What maybe surprised you most about, I don't know, lawyer behavior, the system, whatever it is? If there's something that maybe surprised you the most, what would that be?
When we stood up the ethics hotline and we got permission from our Supreme Court to do that, there was this concern that, well, what if you give ethics guidance and then it turns into a complaint that comes across your desk? What do you do then? And so we built into our disciplinary rules that we have the ability to engage special bar counsel, somebody out of the office. And what's interesting to me and kind of surprising is that in all the years that I've been doing this, we probably haven't had 10 times when some call that we took against an ethics hotline call ripens into a disciplinary complaint. And the takeaway from that is that the population of lawyers that use the ethics hotline and those that don't, they never mix. And so it's very, very rare that we see a complaint arising out of a situation where we received an ethics hotline call.
Such an interesting idea. I talk all the time to lawyers about the need to be proactive, and I have a real good buddy of mine from home, Jack Levitt, who's a business coach, and he has this question that he asks all of his clients. He says, are you running from something or are you running towards something? Are you reacting to things in life or are you being proactive? And it makes sense. The lawyers who have the desire and the initiative to be proactive, to try to figure things out, are probably ultimately going to make the smart decisions. And it makes sense in that regard, I think. Yeah. So what about the biggest thing that you think lawyers need to change? What do you think that if there were anything that you could get lawyers to change, what do you think that would be?
To be receptive to change. I mean, we live in a time when it makes your head spin, right? With the AI and all the technological developments that are impacting the practice of law, and you can't continue to do things the old way and thrive or even maybe survive. So
Yeah.
it's a new day, and one thing that's interesting to me is when we receive these ethics hotline calls, I've got our database open on my computer, and so whoever the caller is, and really we've done this for so long that we get so many repeat callers, so it's not necessary for me to look in our database and say, oh, this is a lawyer who was admitted 3 years ago. So it's a young lawyer, so that's going to be a different conversation than a lawyer that's been practicing 15 or 20 years, because what we're experiencing is that more experienced lawyers will look to find the answer for themselves before they call on the ethics hotline. And when they call, they're just trying to confirm that they're not missing something. And often that is in conflict of interest situations because those rules are clunky and, as you know, and kind of hard to find your way through. And to achieve a comfort level that you're dealing with a conflict in the appropriate way is not easy. The younger lawyers, what we've noticed in Gen Z and late millennials, often they won't even have formulated what the issue is. They just think it feels weird, and they're looking for, some guidance. And many of those calls almost turn into practice management kind of calls. But often with a young lawyer, I'll listen through their situation, their facts, and I'll say, well, what rules have you identified that are in play here? Well, I don't know. That's why I called you. And then I'll say, okay, here's what I want you to do. I want you to read 3.3. I want you to read 8.4D. I want you to read the comments under those, and then call me back and we'll talk about it. So that's the way we kind of deflect back on a new generation of lawyers that are used to being able to find the answer to every question on their smartphone.
Yeah.
So it becomes more of a teaching exercise.
Yeah. Sounds like you become more of a professor. You give them a little bit of homework, let them try to find the answer for themselves, and then bring them back to where it needs to be. And that sounds really interesting. You mentioned things like AI and change and stuff like that. Are you seeing any issues or any questions about AI lately?
I haven't had anything hit my desk what I'm seeing is what everybody's seeing. We're seeing more use of AI to really generate a better product quicker, right? Where I'm expecting that we're going to see the AI problems is where they've already hit, like in New York, where a hallucination shows up in a brief and non-existent cases are cited. So I think that's where we're going to maybe see some disciplinary outcomes, but we haven't seen that yet. We're just
I can't decide if the issues with AI are overblown or if they're real. Don't get me wrong, but I just feel like I don't know. I feel as if because so many people are talking about those couple of cases that came down the pike already, that I can't tell if I can't tell what the rank and file of the practice are doing with it or not with it. You get any sense for anything like that? Any chatter that you've heard?
Yeah, what I'm finding, and younger lawyers are quicker to embrace it than older lawyers. Younger lawyers, when they use it, what I would consider is appropriately or right, I'll have a transaction lawyer say, I ask AI to generate a sheet of deal points on this transaction. So I want to make sure that I'm not overlooking something that I should be writing into a contract or a buy-sell agreement or whatever. And so that at least gives them a template to start from and then take it from there. So I think the way lawyers are going to get into trouble is to over-rely on AI for generate a finished product, but certainly to generate a first draft I asked AI, ChatGPT, to write a 200-word essay on the importance of the invention of the stirrup to Western European history, and you should have seen what it kicked out just like that. I mean, it was amazing, and so it's pretty exciting. And I do think you got to embrace it, and you've got to figure out how to use it right.
Yeah, and I'll tell you got to be careful, as we all know. I did a program once called Ethics Lessons from the TV show The Big Bang Theory, and I'm a Big Bang Theory fan, so I know the show inside and out. I mean, I must have watched it 5 times from beginning to end, on loop. And when I asked ChatGPT, I gave it like a prompt, and I said something along the lines of, compare the plot lines in various episodes from The Big Bang Theory to the model rules of professional conduct, cite specific rules. Like, I really engineered a tight prompt. And the answer it gave back to me was exactly what I had hoped for, except 50% of the plot lines on the show it made up. Not even the ethics issues. The ethics rules it got right, but the plot lines, it made up plot lines to match the rules instead of finding actual plot lines that match the rules.
That's interesting. I had a similar experience in a different context, but we host an annual convention every year in September. And so for last year's convention, I received a call from a really fine lawyer, a past president of the Wyoming State Bar, who wanted to do a presentation on the ethics of AI. And so he had ChatGPT generate the presentation. And he sent it to me and said, would you please review this and comment on it? Well, as I got into it, I just did a red line of what he sent me. There were so many mistakes. There were misreferences to rules. There were references to the wrong rule. And I just did a red line that cleaned it up and substantially. I mean, it was kind of a mess. And to read it and not be burdened by the knowledge of the rules you and I have, it sounded pretty reasonable. But then when I kind of dissected it, that's what ended up being his CLE presentation at the meeting, was what ChatGPT generated and what my red line generated. And I think people received it pretty well.
Yeah, I think one of the most dangerous things is something you just talked about, I think, when it comes to generative AI. And that is, we all know that you're supposed to double check stuff. But what concerns me is what people don't know. You know, they might not realize what something that has to be double checked because it sounds so good. It may be in an area of law that they're not completely sure of, but the sentence sounds right. And as a result, they may double check a lot of stuff, but they may miss certain things. And the same thing happened to me as well. I did a program and I tried to use ChatGPT to write my materials. And it made so many mistakes that I changed the name of the program to ChatGPT is an Ethical Idiot. And I talked about all the mistakes that it made. But that's what struck me, just what you said. Most people don't have the level of understanding of the rules that we do and our colleagues do because it's what we do. It's our area of the law that we practice. And there were so many mistakes it made that if you didn't have a deep understanding of the rules, you wouldn't even know that it needed to be double checked.
Yeah,
that's the thing that gets me for it. Yeah, I think it's definitely the future, and there are a lot of ways that people can use it safely. And I think what you just mentioned, that one lawyer said about generating a sheet of deal points. That's interesting. It's not doing research. It's just what and you could probably enter enough information into the system without using confidential information to be able to get a generic sheet of deal points. Interesting way of looking at it. Okay, so if there's anything that you can get lawyers to stop doing, what would that be? Because we talked about change, what you'd like them to embrace. What about what you think that they need to stop doing?
The save as, the opening an old Word document and saving as, that tends to get lawyers in trouble because they forget to change. We've seen everything from an old caption that doesn't get changed to references to the wrong parties in a pleading. And so that use of prior templates, but not making all the changes that are necessary to make it reflect the current matter is a real problem. And I've made the same mistake. I mean, we all have kind of made that mistake, I think.
How does that manifest itself in the disciplinary system?
Oh, we'll get a complaint that says, geez, the lawyer violated confidentiality because they didn't take this name out or this social security number out, or the lawyer is so bad they don't even have me as a party to the case. You can imagine all the situations of that. And so it has become more frequent over the last 10 years, I would say, to see that as a component of at least what fueled a complaint to be submitted to our office.
And what fueled the complaint was sort of the next thing I was going to ask you about. I often talk in my programs about the quickest way to get into the attorney disciplinary system. I'm curious to know what you think the quickest way to get into the disciplinary system would be.
Family law. It generates so many emotions. And you tend to identify opposing counsel with your spouse or ex-spouse. So we get a ton of family law complaints.
Against the other lawyer.
Oh, it can be client against client's lawyer. It can be client against the opposing counsel. It can come from, and we don't have any standing requirement to submit a complaint, so anybody can submit a complaint to us. Those pretty rarely result in discipline,
Mm.
mainly because family law is hard, and it's hard for any lawyer doing it, and that's why we're losing kind of our community of family law lawyers in Wyoming. I don't know if that's true elsewhere, but so the best when I present on this, I say the best way to get grieved is to A, be a family law lawyer, or B, be a public defender. In public defenders, that's a whole different dynamic. They've got
Yeah.
impossible caseloads. They've got. I often say no client is more demanding than one that isn't having to pay for their legal services, right? And so again, we see a lot of public defender and some prosecutor uh, complaints that all kind of read the same, and again rarely result in discipline.
Yeah, the idea that you talked about all the emotion in family law, and that I think that kind of dovetails into what I always say, and I always say that the quickest way to get into and I'm from Jersey, so I'm going to get a little risque on you here slightly. Although we should be happy that I haven't dropped the F-bomb ones yet during our conversation, which is a big deal. The quickest way I always say is to piss off your client, to make them angry, and what you just said, I hadn't thought about. How family law as a genre, so to speak, just makes people angry
Yeah.
because of the issues that they're dealing with and the emotions.
Yeah. Yeah. The other situation that I've become accustomed to is what I call the trinity of neglect. And that is, as a lawyer, maybe the hardest thing to develop in your practice is when to say no. I certainly experienced that in private practice. I came in as a young lawyer, thinking I could help everybody. And it took me longer than it should have to realize that sometimes the best advice you can give a client is not to do anything and
Mm.
to educate them. So what I call the trinity of neglect is you take a case maybe that you're not really competent in that area, but it looks like a pretty good case. And so you figure you'll learn on the run here. And so you take the case, you find that you're not comfortable with the subject matter. So that's the file that goes up on the corner of your desk and starts to gather dust. And because you're not working the case, you're not communicating with your client, because who calls their client to say, hey, I haven't been working your case? So you're violating, and you're not being diligent. So you're violating 1.1, which is competence, 1.3, which is diligence, and 1.4, which is communicating with your client. We see lots of that kind of a scenario. And so what happens is that the client starts calling, and lawyers are taking the call, and then the clients get frustrated, and then it lands on our desk as a complaint.
And then you can put the cherry on the top of that little ethical sundae when the lawyer, out of their own anger, chooses not to give the file back to that client.
Yeah. Although in Wyoming, we've got an archaic attorney lien statute that absolutely says you don't have to give the file to the
No
client.
kidding.
If there's any unpaid fees or anything. I hate it. I've tried to
Yeah.
we came within an eyelash of getting an amended statute passed in the legislature a few years ago, and just could not generate enough support for it. So.
That's really interesting because I've always felt that the trend is to go away from the attorney liens, and like you said, I guess that's why I use the word archaic.
Right. Yeah, it's really an anachronism. One other thing that I've preached, probably to no avail, all of our discipline cases are, well, almost all of our discipline cases are made on documents, and documents generally means emails and text messages. So the advice that I give to lawyers at every opportunity, which I know I'm just shouting down a well, but don't text with your clients unless it's to schedule things or say I'll call you tomorrow or whatever. But what happens is, and I call it the after five syndrome. You'll
Mm.
get a client that's texting a lawyer after five, and because everybody expects their text to be responded to immediately, right? And if you don't hear back from somebody within 10 minutes, you feel like you're being ignored. And so then maybe the client amps it up a little bit and gets a little more aggressive. And maybe one or both of these people have been enjoying a cocktail or seven. in the course of the evening, and then it's on. And it's awful to see. Clients are keeping all these things now. Everybody's keeping their text messages now. So it's not unusual for us to say, well, I want to see all your emails on this case, and I want to see your phone records for text messages that you've got. And so that's where we build our cases, and often it's just somebody that you send too soon, where
Yeah.
they're betting spleen, and it just looks terrible. And
So is the problem that they don't save the texts, or that the content of the text is a problem?
the contents of the text is the problem. We're seeing save text. I don't think lawyers necessarily do, but you'll get something where a client will rattle off a question, and a lawyer will give kind of a hasty answer that raises more questions than it should, and so that'll
Right.
another question, and pretty soon the lawyer's getting hostile and angry and aggressive, and it just isn't it's just not a great way to conduct the law.
Yeah, it's interesting because I often talk to lawyers and I say the way we communicate in our personal lives tends to bleed over into the practice, and those things end up hurting us. And it's so difficult to say remain. I don't want to say the word professional because you could text someone in a professional way, but it's tough because what I'm basically saying is stay old school. Stay old school. And they get mad at you when you do that because they think that you're trying to tell them not to advance with technology. That's the people that hate me the most in the world of attorney ethics are those people who are trying to get lawyers to use new technologies. And I'm constantly saying slow down. I'm not saying don't use it. I'm just saying slow down.
Yeah.
Yeah,
I think, and the other thing that this feeds into, for me at least, is it's made me really appreciate how much control you can gain on the attorney-client relationship at the front end by having a really detailed engagement agreement, which I would hope would include things like, I will not text with you after 5, or I will not text with you except as necessary to schedule appointments and court dates and those kinds of things. And just really control how you're going to interact with the client going forward. If you call me, you will hear back from me within 24 hours. It doesn't mean I will call you back within an hour. And so you have to set those ground rules and those parameters at the outset of the relationship, and then you need to stick to it. You need to abide by your own rules.
Setting boundaries. Setting boundaries, so important.
I think that engagement letter is a missed opportunity, and I was guilty of it too in private practice. I had a template for an engagement letter, and it was kind of a one-size-fits-all thing, but I really have come to appreciate the importance and the way attorneys can build boundaries, as we said, into the relationship at the outset.
And as we said in the beginning, that's one of those proactive approaches, thinking ahead, being proactive. So maybe that's a good place to end. I know you got a day that you got to get going. I don't want to take up too much of your time. And let's face it, I don't know how long people will listen to us. So we could go on forever, but it might be a good place to end right here.
At least it's interesting to us. But Stuart, I appreciate very much being asked, and I've enjoyed visiting with you.
It's my pleasure. Thank you so much. And I hope everybody enjoyed the program today. If you want to go take a look at my book, you can go to my website, How to Stop Hating the Law. Mark, thank you so much for joining us.